Welcome back to the Law and Crime Network. I'm Heather Hansen here with Dan Schorr. And we were just watching some more of this Flatoff case. And, you know, we haven't often seen where defendants or anyone represents themselves without an attorney. It's an interesting thing. Whenever I get a case that comes into my office where the other party is going to be representing themselves, I'm always like, oh boy, this is going to be a lot more work for everyone. How do you think that that impacted the other people in the courtroom, Dan? The prosecutor, the judge, the jury? How do you think him representing himself changed their jobs in that case?
It's a challenge for everyone, because I've been a prosecutor going against the pro se defendant, and on the one hand, they usually don't make very good arguments, right. So that's helpful to the prosecution. But on the other side, they're not making legally coherent arguments often, and if you're trying to argue against the other side, if you can't even make heads or tails about what they're saying, and often it was erratic here, that's a problem. From the judicial perspective, you're worried about the case being overturned because then later on the defendant can say, listen, I wasn't given a right to counsel, I was never told that I had that right. So that's why you saw here the judge, which they often do, appointed standby counsel to advise him, and the 10th or 11th had to take over at the end. But it's tough. The judges are terrified of having the cases reversed because the lawyer who's the defendant doesn't act in a competent way.
Well, and that's the thing that's frustrating when you're on the other side, is that if it were a lawyer who was representing the other side and doing certain things, you'd file a motion, the case would be thrown out. But because of the constitutional protections that the defendant has, judges are very reluctant to throw these types of cases out. And so, as you said, the arguments may not be the best arguments, but they're almost impossible to overcome until you actually get to a jury, and you've got to go through the process. So it can be frustrating for everyone, and especially for the judge, as you pointed out. Now, the judge in this case was really giving him a lesson in law school, step by step throughout the case. Do you think that that's pretty much the norm in these types of situations?
Yeah, you have to. You have to advise them about what they can do, what they can't do. It takes a lot of patience by the judge, because you have to let the defendant make arguments that you would never let an attorney normally make, because you don't want the defendant to argue, I was shut down, I couldn't represent myself the way I wanted to. So they get a lot of latitude, and the prosecution also is thinking, you know, I can object to this. I know what they're saying is something I can object to and win on, but do I really want to give an argument for appeal? So you back off. So it often turns into a lot of latitude for someone who's erratic and not representing themselves very well.
And to your point, when you're the prosecution in that type of case, you've got to have your questions prepared. And for the witness, you've also got to be prepared for dealing with whatever the defendant is up there saying. And you also have to be thinking, okay, do I really want to make a fuss out of this? Because that might give an appellate issue that otherwise wouldn't exist. So a difficult job. You know, it ultimately, I think that, I don't know the statistics on this, but I would expect from personal experience that most of the time the pro se defendants are not successful. But it takes a lot of hurdles to get there, and a lot of court resources. I mean, these are not inexpensive endeavors to have these cases go that would otherwise perhaps be settled or thrown out of court because someone decides to represent themselves.
Right. One of the advantages of having a lawyer in the criminal or the civil system is they can get to a mediated result or a settlement result because they understand the law, they understand how to weigh strengths and weaknesses. If you have one person who's not a rational actor, it's really hard to get to that point. It goes longer, there's more leeway, as we said, there's the standby counsels that take time. Right, the defense doesn't usually win at the end, but it takes a long time to get to that point where they lose. And it's never a good decision. That's why people are told that you should never represent yourself.
Right, the lawyer who represents himself has a dummy for a client.
Yeah, absolutely. and it's true. Look, when someone's representing themselves, you know they're in trouble, because someone who is thinking logically about their best interest is always going to have counsel. Even lawyers who know the law, if they get into trouble, which they often do, they have lawyers representing them, because they know you can't represent yourself. You're emotionally involved in the case.
That's right.
You can't think in a detached, logical way.
And it's stressful. Litigation is stressful. You know, that's one of the things as we watch these cases at Law and Crime, it's almost entertainment. But it's stressful. And to have the stress of being the defendant and then the stress of trying to prepare an argument, it certainly does lean towards Mr. Flatoff maybe not being quite right. The question is, not being quite right, does that actually rise to the level of getting a not guilty by reason of insanity verdict? Now, we're going to throw to another clip, and then we're going to come back and talk a little bit more about that, because in Wisconsin, there's actually been a lot of cases with these types of defenses made, and one that you might actually remember. So we're going to come back and talk about that in just a second, but in the meantime, we're going to throw to another clip in the Flatoff case.
For quite a few years, when he used to have a tattoo shop in Menasha.
And would it be fair to say approximately 30 years or so you've known him?
Could be about that, up and on.
Now I'm going to direct your attention to December 4th, 2015. Do you recall that evening?
Yes, I do.
And at some point on that evening, did Brian Fladoff show up at your residence?
Yeah, he gave me a phone call asking me to come over and talk to me.
And what did you tell him?
I told him as long as he wasn't drinking or doing anything else, I said, you know, you can come over.
And did he come over to your residence?
Yes, he did.
Do you recall approximately what time that was?
Probably 9-ish, 9 o'clock at night, maybe a little earlier.
And your residence is in the city of Neenah, Winnebago County?
At that time it was.
Now, how did Brian Fladoff appear when he arrived at your home?
He seemed fine. He had a glass with him, a big mug, I thought it was a big coffee mug.
And did he tell you at all why he was at your home that night?
He asked me if I had a key for the Eagle Nation motorcycle shop.
Now, are you familiar with the Eagle Nation motorcycle shop?
Yeah, I am.
And how are you familiar with that?
I just knew about it through many years of doing business there and stuff.
And you know the owner?
Yes, I do.
And who's the owner?
Stephen Arado.
And are you an acquaintance of Mr. Arado?
Not recently, through about 15 years probably.
So
When you left me the message,
you said that you heard me yelling inside of the garage, talking that I'm going to kill people or whatever. You said, funerals, I'm going to kill myself. And you were on the phone with me, you testified that while I was in that garage.
in the Eagle Nation's garage, yeah.
And then you chose to call Stephen Rado and Michael Funk and his friends?
Yeah. Because it was earlier.
Welcome back to the Law and Crime Network. I'm Heather Hansen here with Dan Schorr. And the case that you and I were talking about that recently actually the defense was successful in the not guilty by reason of insanity defense is that Slenderman case. And we were talking a little bit about that. And what did you come up with as far as what would happen to those two defendants in that case?
Well, it looks like those are two 12-year-old girls who lured another 12-year-old girl into the woods, stabbed her multiple times, and she almost died. She was able to crawl out and barely get help. One is getting 25 years. Up to 25 years in a mental hospital, the other one up to 40, but at least one of them is going to be up for release in 3 years. So that's why a lot of people get upset about these sentences, because it ends up being a case where once someone can prove themselves mentally healthy again, they're eligible for release. If it's a prison sentence, that wouldn't be the case until parole was in play, which would be much later.
Well, and the family in that case actually said every 6 months when these girls come up for their evaluation, they have to relive the issue. They have to wonder whether she's going to be getting out. The young girl, the young victim who did survive that attack is going to have to wonder. And so as much as we don't want to put mentally ill people into jail, it's also a system that seems to make things worse for the victim, which is something that we also don't want. So it's a little bit of a catch-22 there.
It's tough. What do you do with public safety threats who committed a crime, almost killed someone, but at the same time there is some argument that there's a reasonable, mental disease or defect that caused it. It's a tough situation that society's continuing to wrestle with.
Well, and so often we don't always consider the victim, especially as time goes on, because, these two girls may well become, sort of famous for their crime, and the victim may just go on to live her life. And that reminds me in large part of the OJ television show that happened last night where, and I want to talk to you about this, Dan, because there's a lot to unpack with this interview that he did many years ago. But before we unpack it, I do want to make sure that we mention that we talk so much about OJ that I feel that sometimes we forget about Nicole Brown Simpson and Ron Goldman and the contributions that they made and their friends and their family and the people who have to go through watching OJ, between his being arrested and put into jail and for the Vegas heist and then now getting out of jail and then last night seeing this video. So first I want to ask you, did you get the chance to watch the video? What were your initial thoughts of what they played last night on Fox?
I did. Well, first of all, your point is really important because two people were brutally murdered in this case, and their families still live with that every day. And these people who died never got to live their lives. The O.J. Simpson, it was fascinating to watch this now 12, 13 years later. And it seems to me to be a confession. I mean, he's talking in the first person. I know he couches it to be hypothetical, and for those who didn't see it, he's talking about what he might have done or what someone might have done if they were him and they committed these murders. But people don't talk like that. If you have your ex-wife, the mother of your kids, killed, you're not going to do an interview where you say, well, this is how I would have done it if I had killed her. You wouldn't even think that concept.
It's beyond incomprehensible to me because, well, first of all, he writes this report, if I had done it or something, that about what it, exactly as you said, this hypothetical version. And then he's interviewed, and the interview actually happened, as you said, 11 years later. And then there was so much public backlash because of just what we were talking about, the fact that he should not have a voice, he should not have a seat at the table. It's really hurting the victims' families. And so Fox decided to, because of the public pressure, to sort of put that in a vault. And for whatever reason, they felt that this was an appropriate time to take it out of the vault. Now, you know, we've seen O.J. most recently at his parole hearing, and we covered that here live at Law and Crime, and he certainly said some things that I was like, just shut your mouth, just shut your mouth, just shut your mouth, as an attorney. Watching him again last night, I was like, this man does not know when to shut his mouth. Do you think any attorney could have possibly told him that that was a good idea?
No one would have told him that. It's unbelievable. He's really confessing to a murder. And when people were debating, is it a confession, is it not, here's the question to ask. If you're a prosecutor, is that statement admissible into evidence if he was being tried now for the murder? And of course it is, because he's talking about these killings. And he could argue it was hypothetical, but certainly it's an admissible statement against him. And I thought one interesting comment was by Chris Darden, the prosecutor who was on that show last night, and he said, I objected to this strongly for them not to air it, but if I knew he had made this confession, I never would have objected to it because I think it's great for the public to see this.
Know this.
Yeah.
Know this. So let's play one of the clips from last night. And ladies and gentlemen, if you didn't watch it, to Dan's point, Christopher Darden commented on it. There were other people who were involved at the time. There was a law enforcement officer who commented upon it. No one from Nicole Brown Simpson's family, they tend to choose to stay out of the spotlight, which I have to give a whole lot of respect for, and really feel badly that we continue to talk about this. But it is something that's in the news, and when we talk about O.J., it really impacts our discussion about our entire criminal justice system and how well it's actually working. So let's watch a clip from last night, and then we'll talk a little bit more about it.
And this guy kind of got into a karate thing. And I said, well, you think you can kick my ass? And I remember I grabbed a knife. I do remember that portion, taking a knife from Charlie. And to be honest, after that, I don't remember. Except I'm standing there and there's all kind of stuff around and
what kind of stuff?
Blood and stuff around. You know, I hate to say this, but this is like.
How is that? I can't even imagine what's going on in his head. To think that this is a good idea, to think that, do you think that he's so arrogant and feels so supported by the public? And especially, you know, he goes on, and I think we have a clip of this, to talk about when he was doing that Bronco chase, the support that he was getting from the public. Do you think that he just thinks he's infallible?
Well, look, if anyone's going to be emboldened, it's a person who allegedly killed two people and there's overwhelming evidence they did and then is found not guilty. Right. And that person is going to feel, wow, I literally can get away with murder, allegedly. And now he's on TV talking about as if he did it. And once again, as I said before, if this was someone that you were accused of killing and you didn't, can you imagine talking hypothetically about how you would have killed the mother of your two children?
And that's
it's just
the point, Dan,
incomprehensible.
that you keep making that I have not really rested upon enough. They have children together. Mm-hmm. And he did this television interview talking about what it would have hypothetically been like to kill their mother. I even just as a good father, you're a father, it's beyond.
It wouldn't even be a thought in your head. I wonder how, oh, my wife was murdered, or my ex-wife was murdered. I wonder how I would have done it if I had done it. Who would even think like that? It's shocking. It's clearly a confession. People can still argue his guilt or innocence, but as again, if I was a prosecutor and is being tried now, that's evidence in trial that he's making those statements.
Do you think the verdict would be the same today? I know that it's hard to say, but there's been a lot of changes in race relations. There's been a lot of changes in the way that we talk about diversity and the way that we talk about our criminal justice system. Do you think that the timing was right, and the other thing that I think sort of plays into this is our current president is someone who was similar to OJ, was well known by the public, was well known for his successes, and sort of like to play off of those successes. I wonder how well OJ's defense would play with the public that he would be putting in front of today.
It's interesting. So much has changed. Back then, there was a lot of distrust of the police, and I think over the next decade, that went away. But now it's often back now.
That's true.
So I think things have kind of gone full circle, and now the police are. I mean, even the case we were talking about earlier today, the defense was there's mistrust of the police. It's a conspiracy, and that might still play strongly today. The thing that's different is DNA. This was kind of the new era of DNA,
absolutely.
Right? And they were able to say this is junk science. This doesn't make sense. And now people just assume there's DNA everywhere. And it's the other side for the prosecution. They have to sometimes argue why the absence of DNA doesn't mean the person's not guilty. But back then, people were skeptical of DNA.
I think both your points are fabulous ones because Mark Furman really was, I think, in a lot of ways, for a lot of people, the reason that OJ was actually not found guilty. And I don't think that would be any different today. I think that we have seen that there's a lot of police officers whose actions you can question. In fact, I saw an interesting tweet about last night, and we were talking so much about OJ definitely did it. And this tweet made the point that why aren't we talking about George Zimmerman? Because a lot of people feel that he definitely did it with regard to Trayvon Martin. And that's why, for me, when I try cases, no matter how they end, I always say I trust the jurors and I trust the jury system. And I do think that in many ways, the OJ verdict made a lot of people not trust the jurors and not trust the jury system. And I think that that's yet another reason why this case was harmful to the public and to our system.
And things have changed. Remember, juries used to be always they were sequestered during a trial in a big case, and that now doesn't usually take place. And it's in large part because of the O.J. Simpson, because they were sequestered for month after month after month.
Yeah.
And the theory is, what kind of normal person can even do that for months and months and months? And now, right now, you'll see juries sometimes sequestered during the deliberation phase, but after O.J., that's not being done. And you mentioned Mark Furman. Look, there was this argument on the defense. They played what they called the race card. And then you have Mark Furman, the detective who worked on the case, on tape using the N-word.
Being
so
racist.
It plays in exactly into that theory. I mean, the defense couldn't have had, and that was in the documentary that came out last year, they showed that, how it just played completely into the hands of the defense. And what's the prosecution going to say? The police are not racist, yet our main witness has used the N-word on tape. So it fell apart.
Yeah, it's difficult. And, a lot of people, on Twitter, were sort of bemoaning the fact that the Johnny Cochran and the Kardashian, Rob Kardashian, that they shouldn't have represented him. But part of our system is to do your best to represent people so that the system actually works. And so using those facts, using the fact that you've got somebody who said something racist on tape, that's part of the system. The other thing that I think would play out interestingly if this case were tried today is social media. I mean, at the time, it was word of mouth that allowed people to realize that the Bronco chase was going on. I remember I was waitressing, and we all ran into the kitchen, and the chefs in the kitchen had something on, and we all watched it together. But now it would be even faster that people would know, because it would be on Facebook and Twitter and Instagram, and everybody would be talking about it that way. It would be interesting to see. Before you sort of respond to that, I want to play the clip where OJ's talking about the Bronco chase and how he sort of found out about what people were thinking.
What I'm seeing, because every time we go by intersections, it was like, where did these people get the time to make these signs, go OJ and stuff? And what was strange is I was being depicted as a fugitive on the radio, but from the side of the roads, it was more people cheering. I just remember listening to the radio, which I think was Dan Rather. It really saved my life.
Right. Because
when he said that OJ had a history, police were at their house all the time, 8 or 9 times. That was the first time that week that I kind of woke up. Hey, man, listen to what they're saying about me. I say, see, this is BS what they're doing here. Get me to my house.
Isn't that interesting that he was hearing only one narrative, or choosing to only hear one narrative? All these people supporting him, holding up their signs, going, go OJ, run, run. And then when he heard the other side of it from Dan Rather as he's driving along, he sort of had this epiphany. Do you think the Bronco chase itself played any part in the trial. I mean, that is a part of the case for me as much as the trial itself, the fact that he was running.
And they never introduced that into the trial, the Bronco chase, which might have been a mistake. But it's interesting, what O.J. says there is that he's heard on the radio that they're talking about him as a domestic violence offender, and that startles him into his reality where he needs to go and clear his name. He's not thinking about the fact that the mother of his children was just brutally murdered, and if he didn't do it, the killer is out there somehow. Right, that's not what's motivating him. It's that, oh, it's so great, all these people are cheering for me. They have signs that they made on the highway. But now Dan Rather's talking about how police have been called to his house, and he doesn't think the number of times Dan Rather's reporting is accurate, and that's what jars him. And that's disturbing also, and also inconsistent with someone who is not responsible at all. One other point, you talked about how defense lawyers, they have to defend people. Alan Dershowitz was actually one of my law school professors after this trial, and I remember him saying to the class, he didn't understand why he's defended so many bad people, Klaus von Bülow, other people, but it was when he defended O.J. that he got a tremendous amount of hate mail. And I remember him asking the class, why is it that I can defend all these other people accused of horrible things and I don't get this public reaction from people the way I got the O.J. case?
But don't you think that people weren't aware of those cases? I mean, trial watchers, the people who are watching now may have been aware of those cases, but I don't think that the public, I mean, I was in law school during the O.J. trial, and we would all sit in the, and I think it made a lot of people want to go to law school, maybe made a lot of people not want to go to law school. You know, it really brought, you know, it made court TV and all of this such a big draw to a lot of people. And I think before that, the other cases that Alan Dershowitz had represented, they may have been in the news to people who were either impacted by the case or who are really into these trials, but not the general public the way that the O.J. case was.
That's a great point. And people saw it play out. It was the story on every channel, every newspaper, just the lead story. There was nothing else. And
I mean, and you see, and we who lived through it still remember the names and all of that. And it's also interesting. I mean, there's something compelling about that story because even the People versus O.J., every generation watched that when it was on and it won all these awards. It certainly is a case that is emblematic of some of the problems in our justice system, but also the way that the justice system works, for better or worse.
Right, and a lot of those issues haven't gone away, and they've changed. People have tried to address them, but you still have the distrust of the police. You have the racial issues, disparity of treatment among black defendants, white defendants, and whether someone who might be guilty and is black can argue that argument, even if maybe it didn't apply to them. And that was the big thing about the documentary. It was about there was all this injustice against black defendants, and O.J. had never been an advocate for that, but yet his lawyers took that as part of his defense. So it's very interesting.
It's a really good point, and it actually reminds me of the second Aaron Hernandez trial, where Jose Baez made it in large part a case about the way that the police officers perhaps dropped the ball and different things weren't done. And, you know, we heard from the street sweeper and was he interviewed and all of these things. So it is a defense that we continue to see. And it's unfortunate. It's unfortunate that there's enough people who have negative experiences with our policemen that that defense is something that they see as their reality. And it's also unfortunate that cases are impacted perhaps by something that didn't happen in that particular case. It's really, you could teach whole classes at law school on O.J.
The other point is law enforcement has to do a competent job, and there was a lot of sloppiness with the way evidence was handled. So even if they're not planting evidence, planting blood, the fact that the blood is not being brought right to a lab, that's not being secured, the police are not going to get the benefit of the doubt if they say, look, I wasn't planting evidence, I just improperly was holding on to this vial of blood or other evidence. That cannot be allowed, and it shows how important it is. And you still see this with some cases where if it's not handled in a proper way, the defense can make a lot of arguments that, look, you can't trust them that they're not planting evidence when it's not following procedure, and that's really important.
And that's the way the system works. There's a reason it's beyond a reasonable doubt, because it's better that a guilty man go free than an innocent man be convicted of something that he did not do. We're going to take a quick break. Are you able to stick around to talk about our new cases? Okay, so we're going to take a quick break, ladies and gentlemen. When we come back, Dana and I are going to be talking about the cases we have coming up at Law and Crime, and a couple of them might just rival the O.J. case. So we'll be right back. Welcome back to the Law and Crime Network. I'm Heather Hansen here with Dan Schorr. And what we next want to talk about is what we have coming up as far as trials are concerned. First of all, Dan, we have this case involving Ohio versus James Worley. Tell us a little bit about what you know about this case, and then I want to talk to you about the bad dreams it gives me.
Sure. Yeah, it's a horrible case where a 20-year-old college student was went missing and was later found dead in a grave a few miles away. She was biking, and there was a sign of a struggle. They found her bike. They found evidence of another individual, and they went by the home of the defendant, Worley. And besides having her blood there and other evidence, they found evidence of restraints and blood in a freezer and a hidden room where you could hold people, and some of his materials, I believe his bike helmet and some other things were found at the scene of the crime. So it seems like really powerful evidence. And years ago, he had been convicted of trying to, well, at least he grabbed another woman and he tried to abduct her, or at least held her restrained, and she was able to get away, and he was sentenced to a few years. So this might be going on for a while, and the question is, not only is he guilty here, but are there other victims out there?
Yeah, I mean, some are saying, is he a serial killer even? Because we have this one case, and it's a terrible case. Sierra Joggin was the young victim, 20 years old, but she had been biking with her boyfriend, and then they split up, and they were in touch via text, and then her texts just sort of dropped off. The mom called. I mean, you know, we've had so many cases, Holly Bobo comes to mind, where people go missing, young girls go missing, and this beautiful young girl, you know, yet again, we're going to hear from a victim's family and the boyfriend and all of these people who have lived through what really seems to the rest of us to be unbearable to live through. I don't know how the defense is going to put on a case here, Dan. What do you think?
There's so much evidence here. There's his DNA at the scene. Her blood is mixed with his blood. Also, when you have in your own home the ability to, you know, a hidden area with restraints, with blood, that shows that this wasn't, even if you could say it was a freak moment where I did something wrong and I didn't have the intent to kill, but you have this whole system in your residence to accommodate this type of activity. And I'm sure they're scouring everything in that home to find out what else they can, and they're looking at other people who have gone missing and connecting them. It seems like a really tough case. Often when there's overwhelming factual and legal evidence, that's when you see the insanity defense. But here, it's so calculated. If he did it this way, if he had the mechanism for holding someone and keeping them alive and then killing them, as the allegations are, it hasn't been proven yet, but that's the allegation.
Right.
You know, how do you say that you weren't appreciating what you were doing?
Yeah, and I agree with you. I mean, in any case like this where there's really just no defense, you think, well, there must be some sort of insanity defense coming. But we'll see. I mean, some other cases where we thought we'd see an insanity defense, we didn't. And so it's going to be interesting and a very, very disturbing case to watch. But we may not see really exciting lawyering and arguments because there's so little there to sort of discuss. Whereas the other case that we have coming up, I'm really eager to watch this case because I do think that we're going to see some really interesting lawyering. And this is the case of Georgia versus Tex McIver, who's accused of killing his wife, Diane McIver. Now, there's a lot at play in this case. Did you read the indictment, Dan?
Yes, I did. I have it right here.
So not only is he accused of killing his wife, but he's also accused of tampering with some witnesses, right?
Right, trying to get coach witnesses about what to say to police, what not to say to police, and that never goes over well. Police don't like it when you're approaching other witnesses. And also, besides the fact that it subjects you to other charges, the prosecution can argue consciousness of guilt. Well, if you didn't think you were guilty, why did you start telling witnesses what to say? So that's a tough case. But these are sometimes the most complicated cases where it's not so much a factual dispute, it's what was in his mind. Was he intending to shoot? Was it an accident? And then that's not as clear-cut as just showing that someone committed a certain act. You have to get into their mind and prove beyond a reasonable doubt what their mind frame was.
Well, in this case, you and I were talking before we even started on air today, what a weird case it is. They were in a car, he and his wife and a friend, when he shot his wife in the car with the friend. It's sort of an unusual way to murder someone, don't you think?
Certainly, it's a weird way to intentionally kill someone. It seems like more consistent, and we don't know the facts yet because they haven't been playing out in court, but it seems more consistent with someone who hasn't thought this through. Maybe there was an argument, maybe there was a fight. If you're intentionally planning a murder, why would you do that in front of a friend while you're driving a car? Right. But look, one thing we know about following the criminal justice system, people do very strange, bizarre, and sometimes evil things, and we don't always think that they're logical.
Well, and this defendant in many ways, Dan, reminds me of O.J. I mean, the level of arrogance, this guy is a well-known in the community. He's an attorney himself. You know, we talked a little bit earlier about not representing yourself. Though he has not represented himself, if you look at the history of the case, he did actually have some of his friends come in and represent him. And there's an argument to be made that perhaps he had a little bit more influence over their decisions than was good for him. One of those friends is named Maples. is no longer on the defense and may actually be a witness in the case. So it's going to get really complicated and reminds me in so many ways of the OJ case because of all these different players, sort of like, the Cato Kalin issue.
Right, bringing your friends as lawyers, right? Cato Kalin was the house guest, of course. It's interesting because if let's say one of us got in trouble, we would know to hire someone else as a lawyer, but would we be restrained enough to stay out of the legal strategy, or would we be saying, no, ask this question, ask that question? And then our lawyers would hate us for that.
Right, and the level of arrogance to say, like, this is the way I want things done, similar to OJ's level of arrogance to think that he could just get away with these things. Now, the attorney that is left sort of standing after the mix-up, which wasn't that long ago, I think the final mix-up of lawyers was in November. We're now in mid-March. That's not a lot of time for a new team to sort of get cohesive and working together and everything. But the attorney that's left standing, this Bruce Harvey, has a reputation as being one of the best. So from that perspective, this is going to be another interesting case to watch, similar to OJ, because you've got some really good lawyering. What do you think they're going to do in this case to put forward a defense?
Well, first of all, you're going to have to show that he loved his wife, because motive is a big part of this. And the defense, the prosecution is going to say he might have had a financial incentive to kill her. The defense has already been saying that she was actually earning more than him, and he had a financial incentive not to do this.
Right.
So they're going to try to say, look, he didn't have a motive. It was a good marriage as much as they could show, and it was an accident. It was a tragedy, and his actions leading up to the death and right after are going to be really important, because are they consistent with how someone acts when their spouse is accidentally shot? If you accidentally shoot and kill your spouse, how are you going to act? And did he act in a consistent way? Not that there's any textbook about how you're supposed to act, but
right. But like having an estate sale where he sold all of her belongings, maybe not so consistent with someone who's worried about the memory of his wife and making sure. And then he apparently owed her $350,000. I mean, money is definitely going to come into play. Unfortunately, in this case, race is always also going to come into play. Apparently, Mr. McIver was afraid of Black Lives Matters, and that had something to do with his defense and saying that that's why he had his gun out and was shooting. How do you think that plays in today's environment and in Georgia?
He's going to have to flesh that out if he's going to make that a defense. Just saying there was some Black Lives Matter people and he got nervous and he had to pull out a gun. Well, was there an imminent threat? Is someone pointing a gun at you? Because that's not, doesn't seem credible just based on that. But the prosecution and the defense are going to really argue those arguments. And a lot of these cases, it just seems there's overwhelming evidence. This is one case that really could go either way.
Without a doubt.
There's not clearly overwhelming evidence against him. If he can make a case that this was an accident and the prosecution can't prove otherwise beyond a reasonable doubt, you can see him be acquitted here. So this is going to be a fascinating trial to watch.
Absolutely. And it's going to have a little bit of everything. A lot of the things that we talked about in the O.J. Simpson case. And it's going to be a long trial, and we're going to be covering it gavel to gavel with analysis here at Law&Crime. So you want to be sure to tune in, because we're going to be hearing, and it's going to be interesting to see whether Tex McIver testifies in his own defense. Because as you pointed out, Dan, if he's going to make the claim that he was somehow some sort of self-defense or defense of his wife or something, he's got to somehow establish, and we see in a lot of these self-defense cases, that's the one time you do see the defendant testifying. Add to that the fact that he's an attorney who probably thinks he can talk himself out of things. I'm leaning towards thinking he might testify.
I would think so, too, because it's not a self-defense, but he's thinking that there's an excuse of why he did it. I would say this is a case where the defense is going to wait and see. How strong has the prosecution case been? If they don't prove what the defense thinks is beyond a reasonable doubt in their case, you might pull back the defendant, because he's going to be cross-examined on a lot of these actions right after the death that may not make him look good, but certainly to explain why he did it and to say it was an accident, if they have a coherent way of explaining that, they may do that. So,
yeah, and if he's as charming as he certainly is sort of reputed to be, that, you know, you could charm a jury. It's going to be a fascinating case. I'm also eager just to watch his interactions with his lawyers at counsel table. If he's sort of bossing them around and telling them what to do, it's going to be one to watch. I'm sure you're going to be back here with us over the course of this trial, Dan, to sort of give us your 2 cents and your legal analysis, and I so appreciate you sitting with me today and going through all of the stuff we had to talk about today.
I really enjoyed it, Heather. It's great talking with you.
Thank you so much. We are still on verdict watch. We are waiting to see whether or not Flatoff, who was found guilty of, I think, 14 counts, is going to be found not guilty by reason of insanity, or whether the jury will find that he goes to jail. We're waiting for that jury to come back. While we wait, we are going to continue to watch some of the clips of that trial. We had left left off at one of the friends of the defendant, and we're going to continue with that testimony right now.